All rise. Voulez-vous le verre? Please be seated.
MICT-13, there is one small point I would like to clarify with you. It may be a matter for the interpreter, but you clarify it first of all. In referring to Dr. Bezosa, the English translation of what you said was that he was of the Rwanda Patriotic Front. I don't know if that has changed, but that's how it came. Yes, it's still militant of a Popular Front. In the evidence, when he gave it, it was translated as a member of the Rwandan Popular Front. I understand that in French there may be a closer connection between these two nouns, member and militant. Can you clarify what is the appropriate English you made today?
Oui, monsieur.
Mr. Altit, sure, Your Honor.
Oui, Monsieur le Président, vous avez tout à fait.
Your Honor, you're absolutely right. When he came, the doctor introduced himself in that way, and I quote, I will do a French translation on the base of the transcript. Member of the Rwandan Patriotic Front. I'm proud of this. I worked with them, with the Rwandan Patriotic Front, and then he says other things. But the way he does this is the way in which we could qualify him. We could qualify him as a militant in French, and even of an active militant.
Thank you, Metraltit. Mr. Elderkin, do you have a role in this?
Just that I've seen the terminology both in the French translation, in other materials, I believe, have been officially translated, and the word militant in French has been translated to activist. So militant in English is not quite the same as militant to activist. Well, be if a question for the chamber, it would be LSS who would have possibly the final answer.
Yeah, well, thank you for that intervention, but your explanation, Maître Altit, a particular question that concerned me. May I, speaking for myself, thank you for the submission you've made, and move on now to the role of the prosecution in this, the proceedings, and give the floor to Mr. Elderkin.
Your Honours, I would actually like to start with a very short period in private session, as I would like to show a short 3.5-minute extract from the February status conference. The section the manager has lined up is from 49 minutes 14 seconds through 52 minutes 50 seconds, and it came from private session in that status conference, hence my request now.
So you wish to present evidence?
I believe this evidence already, for the purposes of the hearing is considered to be in the record. It was one of the court's prior sittings when Your Honour, and it would help to frame an understanding of how we are presenting Mr. Kabuga's fitness based on his displayed competences.
Maître Altit, in relation to that?
Mr. Altit, we do not oppose, Your Honor.
Very well, we shall go into private session.
We're back in open session.
Thank you. Mr. Eldekin, remind me of the date of that status conference?
That was the 3rd of February, Your Honour, of this year.
Very well, thank you. Please continue.
Your Honours, on the balance of probabilities, the evidence before you is that Mr. Kabuga is fit. The defence have not met their burden. What matters is what Mr. Kabuga is capable of doing. As things are today, he is capable of meaningfully participating in the proceedings, and it is in the interests of justice for there to be a trial. Holding a trial, appropriate accommodations in place, respects Mr. Kabuga's rights. It respects also the rights of others with vested interests in the case, notably survivors and relatives of victims of the Rwandan genocide, and respects the common interest for the gravest of international crimes to be prosecuted in all but the most exceptional circumstances. To be clear, the prosecution accepts that Mr. Kabuga is a vulnerable, elderly man, and the time may come when he is no longer fit to stand trial. But that time is not now. The accommodations to adapt trial procedures to assist Mr. Kabuga are important. They do not cure unfitness, rather they reflect that fitness has to be assessed within the appropriate framework that makes an international criminal trial possible in the face of all of the inherent in such proceedings. Accommodations are enshrined in the rules of the mechanism, most notably an right to be represented by counsel, and at a simpler level, for there to be interpretation of the proceedings into the language of the accused. Accommodation system, in view of Mr. Kabuga's age and vulnerability, additional indeed novel, accommodations can and should be made. How justice gets to be done in cases such as those still being prosecuted, for example, in Germany, in relation to charges from the time of the Second World War. If proceedings at the domestic level can be adapted appropriately, that must also be possible at the international level. And you will recall that Professor Kennedy in particular has made a number of practical recommendations that you may wish to consider. A few applicable standard according to which Mr. Kabuga's fitness is to be assessed. The fitness standard set out by the ICTY Appeals Chamber, the Strugar appeal judgment, has been approved in other international courts and tribunals and is the applicable standard. The assessment is a common sense judicial assessment. Second, the test is whether, on the balance of the accused can meaningfully participate in the proceedings. The burden is on the party raising a fitness challenge to make their case. The standard is not something higher, as clarified during the cross-examination of Professor Meze, who misstated the standard in her report. Meaningful participation is not a high threshold. Courts around the world try cases against accused persons with cognitive impairments, accommodating and protecting those accused by allowing for their representation by counsel. Meaningful participation should be determined at a practical level, taking into account the accommodations and protections available. A hypothetical question of testing whether the accused could have a fair trial absent such protections.
Can you clarify the about the role of counsel or the very involvement of counsel? You say around the world try cases against accused with cognitive impairments, accommodating and protecting these accused by allowing for their representation by counsel. You say the fact of representation by counsel is somehow or other an accommodation for persons with cognitive impairments.
Your Honour, I want to be careful not to suggest that there is a cure in terms of the fitness standard where representation or any other accommodation somehow can lift an incompetent accused out of that state. But as Your Honour's heard, particularly during the examination process last week, there were a lot of suggestions as to what role an accused supposedly should play in proceedings, and particularly before this institution in very complex proceedings. And I want to dispel any suggestion that much of the tasks that indeed should be undertaken by counsel actually would fall on the accused, and therefore an accused who cannot do all the sorts of things that belong to counsel should be declared unfit.
Thank you. That clarifies the point for me. Thank you.
Indeed. on the page is to turn to an understanding of what role belongs to defence counsel, what is it that is asked of an accused in the proceedings. The role of defence includes to provide an appropriate interface between the complexities of the proceedings, including, for example, the volume of evidence involved, and the is not expected to be as able as counsel to assimilate and navigate the full body of evidentiary material and the legal framework of the case. And this is from the Strugar appeals judgment at paragraph 60. An accused represented by counsel cannot be expected to have the same understanding of the material related to his case as a qualified and experienced lawyer. Even persons in good physical and mental health without advanced legal education and relevant skills require considerable legal assistance, especially in cases of such complex legal and factual nature brought before the tribunal. That's the end of the quote. The appeals chamber, again from the ICTY, in the Popovich et al. Proceedings, and this is from a decision request by accused Guevara to terminate proceedings, stated, processing the wealth of complex information inherent in international criminal proceedings of defence counsel in order to advise their clients. And I'm spending time on this, Your Honours, because it seemed that at times during the defence's examination of they were reversing the roles of counsel and of the accused. So during the questioning by Maître Altit of Professor Kennedy, and this is from the 31st, page 57, it was suggested that the accused would need to be following what the witness is saying, understanding what the witness is saying, understanding all of the details, the ins and outs, understanding the reasons why the witness is saying what he or she is saying, and also knowing whether the witness is telling the truth or not, and consequently why, or trying to understand the reasons therefore. So it's an exercise of extreme concentration that an accused person has to show, and summarising things. Those explain to counsel, the defence team, what has occurred in his or her opinion. End of the quote. The prosecution submits that this is not what is required of an accused, but rather what counsel must be doing on behalf of their client.
Now, I can see, Mr. Elderkin, that you have some support for that submission, but I note that it seems to fly in the face of the insistence, the persistent insistence of international courts upon the right of the accused to represent himself, no matter how complex the case may be. How do you marry these two essential elements?
Your Honour, the right is the right. Self-representation is enshrined, allowed before the mechanism, previously before the Rwanda and Yugoslavia tribunals. In practice, the majority of accused do choose to take the advice of counsel. Those who do not, accommodations again are made. So it would be, I think, veering into a hypothetical situation. What would we be considering if Mr. Kabuga were insisting on self-representation in these proceedings and he was sitting across the courtroom rather than the defence team? But again, I that it is enshrined, and don't seek to suggest that there is not that right. It's simply one that is not in play in this case and today.
Thank you.
I gave myself numbered points, so I think I'm at 4 here in relation to the standard. Fourth, the Chamber has seen in the experts' reports and heard in their testimony the phrase, fitness is a dynamic concept. Everybody has good days and bad days. A person of Mr. Kabuga's age health, more evidently so. The assessment of fitness does not relate to an accused's bad days, but to their baseline state. They function when they are not fatigued or suffering from the effects of a temporary infection, for example. It would not be in the interests of justice to determine Kabuga's fitness to stand trial based on a time when his cognitive capabilities were diminished, for example, by the temporary after effects of surgery, or when he's simply fatigued. Fifth, the assessment of fitness is not prospective. Mr. Kabuga should not be deemed unfit today because there is a risk that he may in future suffer cognitive decline, rendering him unable to meaningfully participate in proceedings. View of how Mr. Kabuga will be in 6 months, 1 year, or 2 years' time may well be relevant for trial management and analysis, but it should not feature in the assessment of his fitness. This is important because much of what Professor Meze had Mr. Kabuga's fitness concerned her views on his future trajectory, and indeed, much of the defence's cross-examination of Professor Kennedy also focused. But that is not relevant, as I say, to the fitness determination that you are tasked with making today. To continue the point about the assessment prospective, the question about whether Mr. Kabuga is capable of testifying in his own defense should not be considered at the time, should be considered when he may exercise that right, and not before. The prosecution's case comes first, and it would be premature to determine that Mr. Kabuga is unfit as of today, based on a concern as to whether he is capable of undergoing the common question and answer process of witness examination much later in the proceedings. That question might indeed be ripe when it is time for the defense case, if he should choose to exercise his right to testify in his own defense. But it should not be determinative of whether a trial can start and proceed up to that point. I'd add that this question should be considered also in light of accommodations, such as using written questions, or even the possibility to proceed without cross-examination. The actual medical diagnosis of Mr. Kabuga's condition is not of direct relevance to the determination of his fitness to stand trial. Pavle Strugar, the accused in the case that gave rise to the governing jurisprudence concerning fitness, was accepted by the trial chamber to have been properly diagnosed with Alzheimer's dementia. However, the diagnosis was not determinative of his fitness. What mattered then, as it matters now, is functional capacity to meaningfully participate in his trial, not any label given to describe his condition. And from paragraph 61 of the Strugar appeals judgment, I quote, "Medical diagnoses, no matter how many, do not suffice to assess a person's competency to stand trial."
Now, going back to your immediately preceding point, if my memory is correct, the final element in the various capacities that require to be absent or required to be present for the accused to be fit for trial is the ability to his own defense. You're saying that should really be detached from the assessment. And if that's right, is there any authority to support that?
I'm proposing it as the logic that I'm advancing, which is fitness is assessed in real time. So again, if I'm right that there is not a prospective assessment, when there would be clarity on the accused's fitness, capability, let's call it, because I think the capacity or capability is the terminology used in relation to the Strugar non-exhaustive, is at the time when the accused would be coming to exercise that right. And I would say that, as far as I recall from the list of capabilities or capacities, uniquely the capacity to give a statement, testify in his own defence, is the only one that is effectively sequenced away from the others. Obviously, one could not start with an accused unfit to instruct counsel, unfit to understand the evidence, unfit to enter a plea, but those are things that are actions for now. The only action that lies in the future would...
What would you say was the situation if it was clear at this stage that an accused could not conceivably, as matters stood, give in his own defence? You would say, nevertheless, the trial should start if otherwise the test was satisfied. And you must envisage circumstances where that could give rise to massive...
I would agree with Your Honour. If it were clear, as of now, then no, the test is then not fulfilled, that he is fit. But I would question in what way one could make that specific sub-determination. It's clear he could not give evidence in his own case at this stage, particularly before potentially necessary or possible accommodations. So with the functionality required to give evidence were a capacity to be able to answer pre-prepared questions, not face cross-examination, without knowing how the trial would unfold, or without potentially an early judicial ruling or an agreement even by the prosecution saying, we would not cross-examine, then the quite technical questions in play as to what the accused could or would not be fully aired. But in a simple word, clear. Were it clear now, then no, I wouldn't argue at all with Your Honour.
So I think I may have expressed some doubt to Professor Kennedy about the notion of prepared written questions in cross-examination. But it sounds as though you're not sceptical about that as a possibility.
Would have the normal right to cross-examine. Again, we believe our case can be made without necessarily having to run it through a cross-examination of the accused. We believe that the evidence we through our normal witnesses, through other evidentiary materials, would suffice. And if it were to be a swing point that would determine whether the accused were fit or otherwise, I'd be in a position to make all possible accommodations so that that right could be respected without putting the accused in a situation that the bench understood he would be incapable of exercising his right.
Very well, please proceed.
Your Honours, the foregoing is the framework within which the prosecution submits Mr. Kabuga's fitness must be assessed. Now to the evidence that we have available to feed into that assessment. Each of the medical experts has given their opinion on fitness in response to the questions asked of them. In addition, contained within their reports and testimony are a large number of observations concerning their interactions with. Across the various assessments, as well as during the status conferences, particularly of February and May of this year, Mr. Kabuga has spoken of his personal history, presented arguments, as we've seen on the short clip, presented arguments relating to his defence and representation, concerning the change of his representation, and articulated reasons for such requests, told jokes, and spoken of his awareness of the assessment of his capabilities. The clip that I played earlier is, of course, just one example, but the evidence from the complete of observational material, those recordings of the status conferences, the medical reports from the UNDU, and the reports and testimony of the medical experts, demonstrates across an extended period of review that when Mr. Kabuga's physical health is good, when he is properly rested, he can concentrate, communicate, recall relevant facts and events, make choices, and learn and manipulate new information. Taken together, all of these elements form a picture of sufficient cognitive capability to allow meaningful participation. There's no getting around the fundamental difference in opinion between the views the Chamber has read and heard from Professor Meze and the opinions of other specialist experts, as well as of the medical team treating Mr. Kabuga. Professor Meze alone, I believe, and I hope my understanding of Dr. Chuk's report is correct, but with that caveat, I believe Meze is alone amongst all of the medical professionals who have seen Mr. Kabuga to arrive at a diagnosis of dementia. There is no diagnosis of dementia in any of the prior medical records to which Professor Meze had access. Nevertheless, she was adamant during her stating, "I am certain in my diagnosis." And that's from the 1st of June transcript, page 79. This certainty misplaced and beside the point. Professor Meze, alongside Professor Kennedy, agreed in their joint statement that cognitive function, not any diagnosis, was the key question. That's from page 2 of the joint statement. However, Professor Meze nevertheless chose to advance her dementia diagnosis and put it at the centre of her evidence relating to Mr. Kabuga's functional capabilities. Those things the prosecution say are what matter. This creates a circularity in her reasoning, according to which she arrives at the diagnosis, assessment of Mr. Kabuga's cognitive function, then uses the diagnosis to propose that Mr. Kabuga's cognitive functions are lacking because he suffers from that she has diagnosed. If Your Honours would look at paragraph 66 of her report, she dismisses the importance of the diagnosis, but then immediately says that what matters more is the effect his brain disease has on core aspects of his cognitive functioning. Yet, brain disease is the diagnosis she made, albeit stated in more general terms. So Professor Meze says that diagnosis doesn't matter, but in the same breath, she goes on to say that this contrasts with Professor Kennedy's approach. His assessment was founded on a broad-ranging assimilation of observations concerning Mr. Kabuga's real-world behavior, including information from many of those in regular contact with Mr. Kabuga at the United Nations unit and the prison medical facility. Professor Kennedy isn't looking for a diagnosis, but at cognitive function of any underlying medical diagnosis, which is exactly what the Strugar jurisprudence requires. Aside from the distance between Professor Meze's position and the positions of all the other specialists and treating staff, her evidence taken on its own raises and is problematic in a number of ways. First, Professor Meze's methodology is questionable in terms of the sources that and relied upon. According to her testimony, Professor Meze's first step in her assessment of Mr. Kabuga was to read into the medical. Well, Mr. Kabuga's medical history, as provided to Professor Meze, contained no diagnosis of dementia, nor any history of repeated strokes. Terminology is important here. Mr. Kabuga had experienced TIAs, but TIAs are transient and different from stroke. Professor Meze also spoke to Dr. Falker, and she interviewed Mr. Kabuga on the 17th of 2022. That interview included the mini mental state examination that was explored in some detail during Professor Meze's cross-examination. She testified that it was at this stage of her assessment that she formed her first opinion concerning a dementia diagnosis. And that's from the 1st of June transcript 49. After that, and she gave two different versions of this during her testimony, Professor Meze either spoke to Mr. Kabuga's daughter, received the radiologist's report of Mr. Kabuga's MRI scan, translated into English by Dr. Falker, or vice versa. So either it was the conversation with the daughter, then or the MRI scan followed by the conversation. It doesn't particularly matter. At first blush, this gives the impression that Professor Meze's diagnosis, but the core of the evidence used by Professor Meze is much narrower. At paragraph 64, of her report, she stated that MRI conducted recently, in combination with his scoring on the mini mental state, however, is highly suggestive of dementia, as is the additional information by Mr. Kabuga's daughter. Now, as much of what Professor Mezet's evidence about Mr. Kabuga's functional capacities flows from diagnosis, it pays to closely consider how strong are those three identified foundations. Starting with the mini mental state examination, this is problematic, not only because, as Professor Kennedy explained, it is intended as a screening tool for clinical practice. And I refer to transcript of the 31st of May at page 8. But also because in any event, the test is not validated for people with Kabuga's lower educational level, and Professor Mezet could not confirm that it is validated for use with Kinyarwanda speakers. Despite providing a regarding level of education in her report, and that's Mezet's report at paragraph 30, I also note that Mr. Kabuga indeed told Professor Mezet that he had no at all, as indicated in her report at paragraph 3 of the background section. Professor Mezet testified as to her belief that the examination has validity because Mr. Kabuga's scoring, when she administered the test, matched her clinical observations. That's from the 1st of June, transcript page 46. Professor Mezet also testified that a person's cultural background and language would not necessarily be relevant to their performance on cognitive tests generally, or on the mini examination in particular. That's the 1st of June, transcript page 46. And from the same transcript page, she testified that there are a number of questions within the assessment that I think are invariable across cultures, across language barriers, and that actually give you objective evidence of how that person is able to conduct. Your Honours, the prosecution has loaded into e-court one paper from a British medical journal publication called Practical Neurology, which has not been used with evidence. If Your Honours would allow me to quote from it, and in your own time consider whether this would be considered as admissible, for example, as equivalent from the bar table, I will go ahead. If it's clear against, then I won't quote from that paper.
Maître Altit.
Merci, Monsieur le Président.
Thank you, Your Honour. We object. It's new evidence.
Well, so far you haven't tried to present any justification for doing this, and I think you would have to before we could consider admitting it.
Your Honours, I submit that the proposal for this particular item flows from the examination that took place last week, consideration of the most useful body of material that would assist Your Honours in these proceedings. The document, as I say, in terms of a rules basis for admission, Your Honours do have obviously wide leeway proceedings to consider submissions for admission from the bar table. I would submit that in terms of what this potential item is worth, it on its face comes from a reputable publication for a proposition that would be within the normal range of opinions in the scientific community. Otherwise, I would simply refer Your Honours, if it's not admitted, to consider Professor Kennedy's observations as to the limitation of the mini-mental state examination.
I think we should settle for Professor Kennedy. Yeah, we do not consider that reference should be made to this document at this stage, and we reject your proposal. Please continue.
Turning now to the second of those three foundations, Professor Meze relied heavily on information that she obtained from Mr. Kabuga's daughter, Bernadette Maria, indeed devoting 17 paragraphs of her 91-paragraph report to that information. Nowhere in her report does Professor Meze any assessment of the reliability of this information. She described Mr. Kabuga's daughter as a so-called independent informant. During her testimony, Professor Meze confirmed that she found the interview with Ms. Uwa Maria very, very helpful. That's from the 1st of June, page 19. Professor Meze also refers to a letter sent by a Dr. Paulin Murayi, who is Kabuga's son-in-law, again treating contained therein uncritically. Professor Meze confirmed on examination that when she spoke to Ms. Uwa Maria, she told her that she had been asked by the chamber to assess Mr. Kabuga's mental state. That was a question indeed Your Honour posed, and it's at 1st of June transcript, page 78.
We now need to be in private session to continue.
I don't believe so, Your Honour.
Very well, please continue.
Your Honours, the third of those foundations, the MRI scan. The chamber heard from Professor Kennedy about the limitations of scans showing brain anatomy in assessing brain function. That's from 31st of May transcript, page 13. The position taken by Professors Meze and Kennedy in their joint statement in relation to the MRI scan is that which actually Maître Altit this morning read into the record, and interestingly is rather more restrained than the account Professor Meze gave. The reference in the joint statement from page 3 was in terms as follows: we agree that there is evidence of vascular disease affecting the brain and cerebrovascular accidents, evidence on the MRI by patchy, ischemic, and other age-related changes to Mr. Kabuga's brain. As the chamber, Professor Meze's testimony, her views of what the MRI scan showed were much stronger than the view expressed in that joint statement. I would submit to the point of appearing quite defensive. Given that Professor Meze didn't look at the images from the MRI, the English translation of the radiographer's report takes on particular. Professor Meze received her translation from Dr. Falke. The registry has the original report in Dutch and has provided its official translation in English. And that's in e-court as well, for access to the parties and to the trial chamber. There is a fundamental in the two translations of certain key words. Whereas Dr. Falke's translation, as relied on by Professor Meze, refers to severe, degenerative, parenchymal loss of both hemispheres, and that's from paragraph 53 of Professor Meze's report. The official translation of the radiological report reads, considerable generalized parenchymal loss of both hemispheres. And that from the official translation is on page 2. The Chamber may prefer translation provided by the official service to that provided by Dr. Falke, and may wish to consider how such wording could be susceptible to a different interpretation than that had by Professor Meze. That's methodology. Second, briefly, Professor Meze acknowledged that she applied the wrong fitness in her assessment and report. I do note that despite having applied the wrong standard, during my cross-examination, Professor Meze asserted that even a standard, her views would be unchanged. And that's from the 1st of June at transcript pages 66 through, I think, 69. But the lack of care in the wording she used, Professor Meze did acknowledge also during her cross-examination that her work had been rushed. And that's from the 1st of June, transcript page 38. A third problem. Professor Meze's focus on her preferred diagnosis without properly assessing other possibilities is further revealed by her did not perform any tests for malingering. Transcript references 1st of June at page 59. Rather, she dismissed the possibility at hand, expressing the view that maintaining a deceptive posture or modifying his behavior over a sustained period would not be possible. Again, that's 1st of June, transcript 24. Yet, and again, this was elicited despite my submission saying that it's within the court's record and knowledge as to Mr. Kabuga's fugitive years, Professor Meze did learn that he'd been in hiding when she conversed with the daughter. And so I would submit on that basis that we know that this is exactly what Mr. Kabuga managed over an extended period of many years up to his arrest, even including after the time in 2019 when, upon the account of his daughter at least, he allegedly suffered a mental decline. A fourth problem, potentially, with Professor Meze's report, and this is that, according to information provided to Professor Kennedy by staff at the prison medical facility, they had the impression that Mr. Kabuga is much more difficult in performing requests for women. That's from Professor Kennedy's report at paragraph 53. The Chamber may wish to consider whether this apparent bias may have adversely affected Professor Meze's interaction with Mr. Kabuga. Lastly, it may be banal, but still worth noting that the conditions in which Professor Meze undertook her task may be part of the explanation for the problems that her assessment took place at the height of the winter wave of the COVID-19 pandemic, and she admitted during her examination that she had, as I have said, limited time available to complete her assessment and reporting task. That's 1st of June transcript, pages 38 to 39. She spent 2.5 hours interviewing Mr. Kabuga in one sitting, and indeed expressed surprise that Mr. Kabuga could manage that length of meeting without a break. That's the 1st of June transcript, page 39. She also noted that Mr. Kabuga wore a mask for most of the interview and that there was a glass screen in place between her and Mr. Kabuga. Again, the 1st of June transcript, page 38. By contrast, Professor Kennedy split his time with Mr. Kabuga into 2 sessions of about an hour or longer across 2 days. See the transcript from the day, page 54. This may be relevant to the differences in behavior and cognitive ability observed by the 2 experts. Professor Kennedy's description of the COVID in place when he met Mr. Kabuga is simply of 2 tables being pushed together to increase the distance between them. There is no mention in his report of any screen or masks on. And for the 2 tables being pushed together, that's from his report at paragraph 54.1. Overall, supposedly triangulated basis for Professor Meze's opinion is insufficient. When I referred Professor Meze to paragraph 64 of her report and asked her all 3 of the sources mentioned therein as forming the basis of her dementia diagnosis to be equally reliable, she answered, "Well, the MRI is undoubtedly objective and reliable. The information from his daughter, I thought, was again very helpful in just allowing you to pinpoint, if you like, a time where this process may have begun. So that was helpful. I think they're all reliable. You might put a slightly different weight on all of them. And of course, what I've missed out there is, of course, the clinical assessments and the discussions with Mr. Falker and the medical records and his history that have preceded." And that's from the 1st of June, transcript, page 52. Your Honours, as I have outlined, the MRI information is not undoubtedly and reliable. None of the other experts found that dementia was indicated. In addition, as again I've submitted, the translation provided to Professor Meze, which is the only information from the MRI scan of this year, is questionable in an important respect. The mini-mental state examination has not been validated for use with somebody like Mr. Kabuga and does not do the work that Professor Meze needs it to, either in reliably supporting her diagnosis. The information provided by Mr. Kabuga's daughter, as submitted, cannot reliably support her diagnosis. Professor Meze added in as sources for her diagnosis the broader medical file, clinical assessments and discussions with Dr. Falker. But yet again, none of these sources contain or confirm a dementia diagnosis. Sorry, Your Honour.
Yes. Mr. Elderkin, what do you make of the additional report that Professor Matachi Rasso communicated on the 15th of February following his review of the MRI report? He said he had read the psychiatric report of Professor Meze and described it as complete and complementary to my report of 21. He then went on to say the diagnosis of dementia is based on clinical findings. The radiological findings give information on the nature of the process.
Your Honour, my reading of that additional report or statement from Professor Matache-Rasso was that he had his November report of 2021, I believe, suggested that it would be appropriate to seek expert psychiatric assessment of Mr. Kabuga. And I read submission from February of 2022 as simply semantically referencing that indeed he had provided a gerontological report and it would indeed be complementary and on his reading report provided by Professor Meze. I don't read Professor Matache-Rasso as adopting the finding of dementia, and the second part of his presentation of February sets out what, again upon my reading, is simply a general description of what a dementia diagnosis is founded upon, what it is based upon. I do know Professor Matache-Rasso was not given the chance to comment on the report of Professor Kennedy, so I won't speculate as to how he would have addressed that, whether in similar terms or otherwise.
Right, thank you.
So finally, as Professor Meze, a set of additional sources that she says also played into her diagnosis. And for my comments on this, I'd ask if we may go into private session briefly.
We're back in open session.
Please continue.
The prosecution submits that Professor Meze's report is sufficiently problematic that even given the evidence she provided during her testimony, it cannot be preferred to that of Professor Kennedy. And so turning to Professor Kennedy's evidence, I invite actually to heed the words of Professor Meze, who at the 1st of June transcript page 80 said, "I don't want to criticize other doctors, and there are always going to be, but I think that the more information you have, the more confident you can be in coming to a diagnosis. I would invite the chamber to consider the of information Professor Kennedy relied upon to form his opinion, by contrast to the information relied upon by Professor Meze. Professor Kennedy reviewed. He had extensive consultations with the UNDU medical officer and the UNDU deputy medical officer, the UNDU physiotherapist, 2 UNDU detention officers, a general practitioner from the prison hospital, and a senior detention officer from there, interpreter, UNDU nurse, a prison hospital nurse, and in addition, he watched the videotape recordings of the hearings of the 21st of June of 2021, the 6th of October 2021, and 3rd of February 2022 and read the transcripts of those hearings. And that's set out at Professor Kennedy's report at point 9. I would also refer your honours to Professor Kennedy's long account of the variety of behaviour that he observed or was told about by non-partners concerning Mr. Kabuga. There are many common sense examples in Professor Kennedy's report of Mr. Kabuga doing things such as telling sophisticated jokes. The defence this morning questioned the significance of this particular observation. I note that Professor Kennedy was interested specifically in the relevance to the circumstances they were in and the sophistication, not the mere fact of it being told. His observation of Mr. Kabuga recounting his personal story, engaging in discussion about television and current news from Ukraine, even learning some Dutch. If Mr. Kabuga can do these things and more, he can meaningfully participate in a trial supported by counsel. Did not suggest that Mr. Kabuga is the picture of perfect health or that he has no cognitive difficulties. He explained that Mr. Kabuga's thought processes are slow. That's from the 31st of May, age 70. And he would need extensive accommodations in order for him to go through the trial process. Professor Kennedy accepts that Mr. Kabuga's condition may during the coming months and years. However, as of today, his conclusion is that Mr. Kabuga can meaningfully participate and so is fit to stand trial. Is based on a broad body of evidence gathered from a range of sources who, apart from Mr. Kabuga himself, are not invested in the outcome of the assessment process. While the views of Professors Meze and Kennedy have been placed at the centre of this process of determining Mr. Kabuga's fitness, the consistency of views of Professor Metache-Rasso are material. Professor Metache-Rasso, the only gerontologist to have provided expertise, found Mr. Kabuga fit to stand trial, dating only 2 months prior to that of Professor Meze's. He explicitly considered and rejected the possibility of dementia. He stated that we have to keep in mind decline has not yet the characteristics of a dementia. And that's from his November report of 2021 under the heading Considerations. The information available to Professor Metache-Rasso at the time of his report in November 2021 was substantially the same as that available to Professor Meze 2 months later. The to Professor Metache-Rasso included the information that Mr. Kabuga had previously suffered from TIAs, transient ischemic attacks, which, as the name is, transient episodes. Again, I reiterate, not the same as strokes. This history, taken together with all the other information available to him, did not lead Professor Rasso to diagnose dementia. There is no indication in the medical records that Mr. Kabuga suffered any additional strokes or significant events that could have led to his condition deteriorating so significantly between the time of Professor Metache-Rasso's assessment and the time of Professor Meze's assessment. And in answer to your question, Your Honour, I've already referred to the subsequent short additional report of Professor Metache-Rasso. Now Dr. Bizoza. He, unique experts in being able to converse without...
Just give me a moment. Mr. Elderkin, can you help me with how long you might be now?
To 15 minutes.
Can the interpreters tell me, please, whether that's okay or whether we need to break at this point?
Your Honour, I think that's perfectly fine for us as well.
I'm told by my colleagues I may even do it in 5.
All right, I'll give you 5.
So Dr. Bezosa, the reference to his ability to converse without need for interpretation is from the 31st of May transcript, page 85. End quote.
Just a moment, Mr. Elderkin. Mr. Metaltit.
Merci, Monsieur le Président.
Mr. Altit, thank you very much, Your Honor. Sorry to interrupt you. I'm not sure that the detail of the interview can be public. The details of the interview between the Rwandan expert and Mr. Kabuga. The prosecution gives us many elements and details about discussion about the charges, but I'm not sure that this extract can be public.
Why is that?
Mr. Altit. Well, everyone in the defense team has their own opinion, but each and every one of us think that it shouldn't be public because of the presumption of innocence, because Félicien Kabuga speaks of his counsel, in particular regarding the charges, and there's no reason for him to speak on the substance of the trial through an expert about whom I said what I thought, and echoing things that are very discutable. And I forgot it is a medical interview, and by nature, a medical interview is confidential, unless Mr. Kabuga wants, for such or such reason, and through the voice of his counsel, this information is public.
Mr. Elderkin?
I frankly don't see the logical difference between how the content in an open session of matters from the Meze and Kennedy examinations would differ from what was said between Dr. Bezosa and Mr. Kabuga, nor would I consider there to be legal privilege issue adhering to this. But that to me is, I don't fully understand.
Metaltit?
Merci, Monsieur le Président. Oui,
Mr. Altit, well, the difference is very simple. Mr. Kabuga and myself decide of what can be public, and the prosecution has nothing to do in this, and they need to preserve the validity of medical information and cannot talk about what could have been said, according to the expert, about the charges.
Thank you. Mr. Elderkin, we take the view that even what's said there as a denial of guilt rather than anything adverse to the interests of Mr. Kabuga, it nevertheless is comment case made in answer to a question put to him in the absence of any legal representation, and consider that it's on the record anyway, but it ought not to be public at this stage, and therefore that will. So that will happen. You may now continue.
To note for Dr. Bezosa that as he testified, he had considered dementia as a diagnosis, but that it was not consistent with his observations. And that's from the same site that I gave slightly earlier, 31st of May, transcript 85 through 89. Finally, Your Honours, a word about Dr. Chuk. I note that her recent assessment took place on a day when she was told that Mr. Kabuga had not slept well the night before. And Mr. Kabuga told Dr. Chuk that he was very tired. The assessment of Mr. was on a day when he was, for clear reasons, likely to be well below his baseline state, and so is not instructive for purposes of determining his fitness when functioning at his normal level. Your Honours, I guess this is a question that comes up because, again, a document that was only provided to the prosecution after, I believe, Dr. Chuk's report is her CV. We didn't see that at any earlier stage, and we have put that in e-court, and I would invite Your Honours to consider that since there was no opportunity to examine Dr. Chuk.
There can be no objection to the bench considering the CV of Dr. Chuk.
Aucune objection.
Mr. Altit, no objection, Your Honour.
Her expertise is as a general medical practitioner with no special qualifications, training, or expertise in mental health disciplines such as psychology. Given that the question of Mr. Kabuga's fitness to stand trial is ultimately a question of his mental capabilities, Dr. Chuk's lack of relevant expertise, the prosecution submits, determine that her report should not be given any weight in arriving at the fitness decision. To conclude, I reiterate the importance of not conflating speculation about how the future may unfold, even if that speculation comes from a medical professional, with the present observable situation. A large part of Professor Meze's report and testimony concerned speculation about Mr. future decline, whereas Professors Kennedy and Matache Rasso and Dr. Bezosa provided assessments about his present capabilities, which is what the test exclusively should consider. It is now for the Chamber to determine the weight of the evidence on either side of the balancing point. There are the opinions of Professor Meze and Dr. Chuk, which must be severed from their extensive speculation about how Mr. Kabuga's future health may unfold. Professor Meze's evidence must be probed to test whether what the prosecution submits are indeed weak foundations, while Dr. Chuk simply does not possess relevant expertise. On the other side of the balance weighs all of the other evidence that you have before you, from the medical records, from the reports of the treating physicians, from the assessments and of Drs. Matache, Rasso, Bizoza, Professor Kennedy, and from your own observations of Mr. Kabuga's ability to engage with these proceedings. For the prosecution, it is clear the preponderance of the evidence establishes Mr. Kabuga's fitness to stand trial, and we stand ready to start that trial as soon as we are ordered. As for the separate question of Mr. Kabuga's transfer to Arusha, I'll be even more brief than Maitre Altit on that point. We are in the trial chamber's hands. Our interest is for proceedings to happen, and to happen expeditiously. Your Honours, those are my submissions.
Elderkin, thank you very much for these very helpful submissions. My thanks ought also to be extended to the interpreters for their indulgence and for the very helpful concession they've made to what has turned out to be a longer than anticipated session. Is there anything you have to ask? Is there anything you wish to? The trial chamber are content with the submissions that have been made. That therefore brings to an end this hearing on the expert evidence tendered the pre-trial proceedings. A written decision will be issued, we hope, by the end of this week, certainly as quick as humanly muster, a complete and reasoned decision. We will not issue an incomplete decision with reasons to follow. So if our hope realized, you can be assured that the decision will be issued very quickly after the end of this week, but I expect it to be in the course of this week. The court is now adjourned.
All rise, voulez-vous le verre?